My firm, as I mentioned, we do a lot of real estate related activities. We represent a landlord that has about 1,200 tenants, and we represent landlords that have 1 or 2 houses. So we represent everybody across the board. The other thing is that we're also participating in the Genesee County Bar Association's referral program. And I don't know if this is still true, but at one time we were the only firm that would take tenant side cases. Everybody else that was on the referral only took landlord cases. So if you're an existing landlord, you might already know some of these things. But I want to go through some of the stuff you have to remember. I had to tailor this to both landlords and tenants. So if you take a look on there, I want to make sure everybody understands that in Michigan, leases are governed by the Truth in Renting Act and the Landlord and Tenant Relationships Act. One of those acts, the Truth in Renting Act, tells you what's required to be in a written lease. Now, there's a misconception out there that you have to have a written lease. You do not have to have a written lease. You can have an oral lease. But if you do have a written lease, it must have certain provisions in it. Okay? Those provisions can be found in the Truth in Renting Act. And if you look on there, it's MCL 554.631. You guys don't need to remember that kind of level of detail. What you need to know is that if you have a lease, you have to have certain things in it. One of the things you have to have in it is the security deposit notice. If you look on there, it tells you that when a tenant moves out, the tenant must notify the landlord within 4 days of moving out. Okay? Now I will tell you that if you have a written lease, you must have that notice. I will also tell you that 90% of the time the tenants don't read it. They don't remember it, they don't realize that. Okay? That's kind of a big deal. The way that this works is that, and I've got it, if you want to, I hate to get out of order a little bit, but I'm going to do it. If you flip to the middle of this thing, it says the deposit considerations, step 1, step 2, step 3. Flip there real quick because it gets a little bit clearer what I'm talking about. And this relates to both landlords and tenants. The step 1 right there is that if the tenant vacates the premises, they have to leave the property in good condition and then notify the landlord in writing within 4 days. That's that notice that's on the first page in bold print. Here's why that's important. If a tenant moves out, the landlord may or may not know that they moved out, and they also might not know where they went. So the statute's put in place so the tenant has to tell the landlord where they went. That creates the first timeline, the first requirement of what somebody's supposed to do. So I'm the tenant, I move out, I moved over onto James Street, now here's where I'm at. The reason why that's important is because step 2, if you look, keep following through, the landlord has a duty to go ahead within 30 days and do an itemized list of damages. Now that dovetails back to another segment of the Truth in Renting Act, which is the move in, move out checklist. And I know I don't want to seem overly confusing going back and forth, but it's important to know how these things dovetail. I talk to tons of landlords, I talk to tenants all the time. I talked to a tenant today, as a matter of fact, absolutely today, who moved out because the landlord out in Grand Blanc had not been taking care of the house. She had notified the landlord several times in writing that the house wasn't being taken care of. The landlord had made some feeble attempts to take care of it, but it still wasn't right, and the tenant had notified the landlord. Then a month ago, the tenant said, in April, I'm not paying you until you fix what's wrong, and I'm withholding rent. I'm going to escrow the rent. So that happened in April. Now, I recommend that if a tenant does that you do it in writing, but she didn't, but that doesn't count, that doesn't matter. So she didn't do that. Then what happened was, in May, the landlord went to evict the tenant. Now, there was no paper trail. They had a dispute, the tenant wound up moving out. Well, all these timelines start to matter now, all right? The tenant didn't realize, she never read her lease, that she had to provide her address within 4 days. So she never provided her address, all right? Why that becomes important is because if you don't do that, then under step 2, the statute says, when the landlord has to send you notice of the damages within 30 days, if you didn't give them your address, the landlord doesn't have to do it, okay? All right, so now why is that important? The next reason is this. Let's say you're the tenant, I'm the landlord, okay? You moved out of the house, what's your name?
Sarah.
Sarah, congratulations. You just moved out of the house. But you didn't give me your address, okay? You have a $900 deposit. I go through, I look all around, and I find some things wrong with the house, $600 worth of stuff that is wrong with the house. You don't give me your new address. I don't know where to send the check to, I don't know where to send the deposit to, I don't know where to send the itemized list of damages to. So in Sarah's case, I don't know what to do, I keep her money. Sorry, Sarah. Now, 40 days go by, and Sarah says, can I have my deposit back? And I'll say, no, there's damages. I don't know what to tell you, but there was damages. And I couldn't mail the notice to you, because you didn't give me the thing. You didn't give me your address in writing. And you say, I didn't know I had to do that. And I say, look at the back page of your lease, right above your signature, it says, in bold-faced type, because it's required for landlords, it has to be 12-point type, that you have to do it. So because you didn't follow the first step, I'm relieved of following the second step. Okay? So that's why these things dovetail together. Change the scenario a little bit. All right, we'll pick on somebody else. Margaret, you're the tenant. You move out, but you read the lease. So you move out, I have a $900 deposit with you, but when you move out, you tell me, straight up, I'm moving over here, here's my new address, here's my keys, you have your brother come videotape, you hand it to me, I have no way around it, it's in writing, I know where you are, okay? Now, 30 days go by, you don't hear from me. Nothing happens. 40 days go by, nothing happens. 45 days go by, nothing happens. Day 50, you as the tenant are sitting in my office, saying it's been 50 days. I gave the guy my address. I have not heard a peep out of him. He's got $900. You know what happens to that landlord? More than that, I'm suing him. Big ugly letters coming. I'm going to get double damages, and I'm also going to get my attorney's fees. Because what happens is the landlord has to follow the rules. The way this works on the security deposit thing is that there's checks and balances on both sides. So you have to provide your address within 4 days. If you do that right, then you have to provide me with the itemized list of damages within 30 days. Let's assume you both did it right on the first step. Now, Sarah as the tenant got the itemized list of damages from the landlord, and you dispute it. You say, you know what? If I remember right, there was already a big hole in the carpet, and that screen was already ripped, and there's some other paint issues. So all these items are not my fault. So what do? Well, according to statute, that's step 3, you have to dispute that in writing within 7 days. So you get the itemized list of damages, the landlord's going to withhold $600 of your $900, and you disagree with that. You respond within 7 days in writing and say, no way, none of that stuff was my fault. Now then you go to step 4, by statute, these are actual statutory, it's required. Step 4, the landlord must file a new lawsuit within 45 days, okay? If either side misses these deadlines, the other side is relieved of their obligation. I will tell you, the landlords that are professional landlords know these dates. It's too easy to not know these dates. But the tenants, even the tenants that I call professional tenants, they've been renting for a long time, don't know these rules. They don't bother to read them, they don't bother to pay attention to them. I will tell you that what happened to that lady this morning, exact same thing. She didn't bother to follow the dates. In her mind, she had notified the landlord several times that there was defects. The landlord hadn't fixed them, and so she moved out, and so the landlord automatically had to get back her deposit. That's what she thought. Well, the problem is that now the landlord is saying you owe me 1 month's worth of rent because you didn't pay that last month that you withheld. Plus, there might be damages to the carpet and the paint and all the other things. Plus, all these other items. And the problem is that, let's be realistic. I charge $2.15 an hour. If we're fighting over something, it better be more than that, or we better have an ability to get our attorney's fees back for you, or else you're wasting money. If a landlord keeps your $900 deposit, or your $500 deposit, or your $300 deposit, or whatever the deposit is, and you have to come hire me to sue them, I got to have the ability to try to get the attorney's fees. If I can't get those, then you're throwing money out the window, okay? And I tell that to tenants. That's why I had to tell that lady today. If she would have given the 4 days notice, the new address, she would have put the onus back on the landlord to have given her the deposit damage report within 30 days. And then she could have disputed it. And it would have dovetailed, and I would have had a shot at the attorney's fees. But as it stands right now, her deposit in this case is only $580. And I said, unfortunately, you are kind of being wronged, but there's not a remedy that makes financial sense. Does that make sense to everybody? Now that's just on the deposit thing. I want to flip back a little bit. The next thing is that inventory checklist on page 1. See how it's bold in my handout? That's because it's required by law. If you have a written lease, you need to have this language in there as well. The move in, move out checklist is important to both parties. I would say that it's probably more important to the tenant, but it's important to the landlord too, because if you have a place that you just rehabbed, it's nice and clean, and the carpets are nice, and the fresh coat of paint, then this thing should be clear, no problem, okay? And the tenant should see that. But at the same time, if for some crazy reason it's a worn house, it's not brand new, well then it's fair for everybody if it lists exactly what the status is on it. I will tell you that I've also had tenants where they've been told you're responsible for X, Y, and Z of damages, which the tenant disputes, and which the landlord sues, and now we're in some kind of a court hearing, and we subpoena the old move-in, move-out checklist from prior tenants, and we find the same list of mistakes or errors in the house. That's why it's critical for a tenant, because you get to look back and see. The 2 tenants ago said there's a big hole in the kitchen wall. It never got fixed. There's still a big hole in the kitchen wall. I moved out. There's still a hole in the kitchen wall, and you're trying to blame me for the hole in the kitchen wall. Well, how many deposits are you going to keep that hole in the kitchen wall? They're not going to be mine. Okay? Want another one? Yeah, please.
All right.
Here you go. All right. So it's important that language is in there. The next list is, I've already talked about it, is the notice for 7 days. That you have to respond if you dispute that within 7 days. Now I'm on page 2. I'm going to go to the landlord considerations. This is geared more towards landlords, and the next section is geared towards tenants. But for landlords, you're doing a landlord around here, you already know what I'm talking about. You want to make sure you're in the right court. There's a lot of reasons why you want to make sure you're in the right court. That's the jurisdiction and venue. What I mean by that is, currently we have the 67th and 68th district courts. You cannot do an eviction in a 68th district court, which is the city of Flint, if the house is in Davison, and vice versa. I will tell you that we have several judges that, and they all should pay attention to this, but we have several judges that particularly pay attention. And if you file in the wrong court, your case will get dismissed. It means you just wasted $45 for the filing fee, plus you just wasted $25 per person for having them served, at least, sometimes more, and the time element. You've just wasted all the time. Now you're starting all back over from scratch, okay? So it's very important that you pick the right place. If you're not sure, call the court. Give them the address. Even that sounds a little bit sketchy, but double check it. If it's a place you've already had for a while, then that will not be an issue. Step 2 is to serve the tenant with a written demand for possession. Now, I'm going to explain this for the tenants a little bit, but actually I find sometimes it helps the landlords because they sometimes, especially if they're newer landlords, don't understand the difference. There's 2 main types of notices to quit. There's what we call a 7-day notice to quit, which is a non-payment of rent notice to quit. That says, you owe me $500 for June's rent, you haven't paid it, you've got 7 days to pay it. Okay? Then there's, if you don't, we're going to go to court. The other one's a 30-day notice to quit, which we all refer to as 30-day notice to quit, but it actually on the paperwork says termination of tenancy. That one says, I don't really care about my money. I'm done dealing with you. I want you out of my house. Now they can ask for money separately if they want to, but generally the 30 days says, I want you gone. Bye-bye. Get out of here. Here's your 30 days. And the law allows for that. So when we look at those, it's important to decide which one you want. I will tell you that every now and then I get people who have started one side of the process and switched to a different side of the process, not knowing it, using the wrong set of forms, the wrong notice, the wrong complaint, and back and forth, back and forth. Any one of those defects, depending on the judge you get, it might be fatal to your case, makes you start over again. All right, and that costs everybody more time and more money. So what you want to do is make sure you're going after the right remedy. Whichever one that you're looking for, make sure it's the right set. Most common is obviously the 7-day non-payment of rent. You owe $500, you haven't paid $500. I will tell you that, especially in our area, I think that there are some really good landlords. There's some really bad ones always, but there's some really good landlords. I have seen cases where they have bent over backwards because of the tenants, the people. You know what I mean? They kind of care about the people and they want to help. where the landlord has let it go for 2 months or 3 months or 4 months or taken a couple partial payments. The problem with doing that is that once the tenant gets so far behind, if they can't get help from an agency around here, they're going to have no choice. They owe $2,000 or $2,300 or $3,500. When they get that far gone, if they can't get help from an agency, they're going to have no choice but to kick them out. When it might have made more sense, they might have been able to get back on their feet and get some help if they had started the process when they owed $500. You know what I mean? And if anybody knows what I'm talking about, there's several agencies in our area that will help if you have a judgment. All right? Everybody know what I'm talking about? Getting the judgments? Okay. So that's the issue. You have to pick which one you want. There's another issue that's out there. It's called the supplemental complaint. It costs $45 to file a landlord tenant case. Either one of those first two options we're talking about. It costs an additional $45 and can be more if it's a lot of money, but generally it's only $45 more for a money judgment. Here's what's important about a money judgment. I'm going to kick you out. I'll switch you. Linda, I'm going to kick you out, Linda, because you owe me $900. It's Linda. If anybody's wondering, it's Linda that owes me $900. Linda owes me $900. I'm going to kick Linda out. But I know that Linda has a good job. I don't really know why Linda's not paying me, but I know she's got a good job. So I think that I can garnish her wages in the future. I'm going to have a shot at collecting from Linda down the road. So I decide I'm going to pay the extra $45. What happens is, if I get that money judgment, I will be able to do exactly that. I will be able to go to Linda's job, garnish her wages, try to get her tax return. I will be able to go get my money from Linda eventually. Okay? Now here's the wrinkle to that. If you don't pay for the supplemental judgment, the extra $45, you have no right to collect the money. So let that soak in for a minute. If you only do the original $45 to get the case into court, all you have a right to is possession. So the money judgment makes you have the ability to collect the money. People get completely confused about this all the time. All right? It is kind of a big deal. If I say that Linda owes me $900 plus court costs, and I only have paid the first $45, then Linda's going to have 10 days to pay me the $900 plus court costs, and she can stay. If she doesn't stay, I can have the sheriff throw her out. That's all I can do. Once she's gone, that's it. That case is over and done. I can't go collect without doing some other steps. Okay? If I pay the extra $45, then I can go back after Linda. And I can then go garnish her wages, I can go collect her tax return, I can do all kinds of things. But I will tell you, there's some extra wrinkles that go with that. In order to secure the money judgment that I'm talking about, you absolutely must, it's required, personally serve the person. All right? And a lot of people don't understand what I mean by that. If I want to go pick on Linda again, I'm pick on Linda right now. If I'm going to go kick Linda out, Linda owes me $900 for 1 month's rent, and I'm not looking for a money judgment, what I can do is file the paperwork at court, give it to the process server, tell the process server, go find Linda. If they can't find Linda, as long as it's 4 days before the hearing, they can run out, tack it on the front door, good enough. Okay? If Linda's on vacation, out of town, working a double, and doesn't see it, or her neighbor rips it off the wall, or anything happens to it, doesn't matter. As long as that neutral process server says he served it, tacking on the door, good enough. I show up at court, Linda doesn't show up because she doesn't know. Judge says, I grant you 10 days, Linda's got to be out in 10 days. The court will mail her the notice that says that, and then I've got a copy for myself. In 10 days, if Linda's stuff is still there, I get to go ahead and have the sheriff throw her out. Okay? And I might have never actually served her. She might have never actually seen it, in theory. She would have had lots of mailings. She would have known she's not paying her rent, so it shouldn't be a total surprise, but she might not have ever been handed the paperwork. The money judgment part we were just talking about, it's not the same.
What was the total number of time, or how many days was that total? You said that they have 10 days.
Right.
By the time they turn your paperwork in the court, they send it to her. What are we talking the time frame?
From start to finish?
Yeah.
Well, on a 7-day, the fastest that you could do a 7-day total, start to finish, is rent's due June 1st, they haven't paid. You mail out the 7-day notice a couple days later. Let's say it's June 3rd. Okay, you mail out June 3rd. They've got 7 days. Now we're to June 10th. They haven't paid. June 11th, you file in court. The rule says it cannot be any closer than 4 days, nor any more than 10 days. for the court, for your court. So figure 7 is going to be the average. Okay? So now you're on June 11th, and you have to serve the in court the next week. So it's June 18th, you're in court. June 18th, you show up at court. The person either doesn't show up, or they show up and you have consent. If they do that, from that day, the court gives them 10 days. So June 28th is the last day they can pay. June 29th is the first day you can have the sheriff throw them off. That's on a 7-day. That's if everything went perfect. I mean, right down the line. And that's, in theory, the way it should go. It doesn't always go that way. So, but that's the fastest on that one. For the 30-day termination tenancy, it's about 46 days if you did everything right perfect. Okay? But here's the wrinkle. I will tell you that collecting on a judgment is extremely difficult. It is difficult, even if you pay for the money judgment. But also, the personal service is difficult. Now, if I'm trying to get that money judgment, I've got to find Linda. My guys have to put it in Linda's hand. If not, if they just tack it to the door, when I show up at court, the court will not give me a money judgment. Now, as a lawyer, what I do when I get there in that situation, I don't want to adjourn. I have 2 choices. I can adjourn the case a week and try to put it in Linda's hand during the next week. Okay, it's got to be a minimum of 4 days in advance. Or, and this is more often what I do, unless my client objects, is I go ahead and say, Judge, I would like to take the possession judgment today. I'd like to preserve the money judgment until such time as we get personal service. The reason why is I want that property back as fast as I can get that property back so that my client can evict the person and get a paying tenant in there. All right? I want to keep it moving. I don't want to delay anymore if I can help it. That's pretty important though, because let's imagine that you're a landlord with 25 houses and you have to do, 50 evictions a year. Maybe not put that many on 25, but you have to do a ton of evictions. If you pay $45 for extra for a money judgment every single time, and you don't collect that money, or the person doesn't have a job or they're collectible, or they're on Social Security disability, or any other number of things, or you have to keep adjourning the court dates to get personal service on them, you just wasted all that extra $45 per case. So most of my landlords don't bother to pay the extra $45. We just want possession. That's it. All right? So hopefully that makes sense. Step 5 is if you show up, if the tenant doesn't show up, the landlord's automatically going to win. All right? So it's a default judgment. What I tell people, a lot of people wind up in this situation because they had their house foreclosed on. Usually not how it's happened, but it does now quite a bit. The house is foreclosed on, their 6-month period of redemption is expired, and now the bank is coming to try to evict them. What I tell everybody is this. It's not a secret. Show up at that court date. I will tell you, a lot of people say, I'm not going to show up at the court date. I have nothing to argue about. I don't have a lease. I lost the house. There's nothing for me to say. That's not necessarily true, number 1. But number 2, around here, if you show up, you can ask, they don't have to give it to you, but you can ask for 30 days to get out. For the writ date, which is the order of eviction, to be issued 30 days from today. If you don't show up, it will only be 10 days. By statute, it will be set within 10 days. On day 11, there could be a sheriff there to move your stuff for you. Okay? So I tell everybody, just show up, because you can do yourself a favor by buying more time. So that's kind of a big deal. If the tenant does show up, this is a tip for any landlord. No matter how acrimonious it's been, even if you don't get along with the tenant at all, my opinion, hold the tenant out in the hall and try to settle it. Pull them up. One of the things that I like to do a lot is to sit down and listen to what they have to say. You'd be amazed. Sometimes it's a communication issue. Honestly, sometimes with the client that was there today, it was all about, I think it was ants. They had not fumigated for ants. That was it. Had the landlord fumigated from ants, this lady probably would have stayed. They would have had no dispute. And I don't know how that was not clear, but she had a bunch of extra gibberish in her letter to the landlord that was not relevant. And so I assume that got lost in the white noise of it. And all she really wanted was ants dealt with. So what I do is I pull them outside, pull the tenant outside and say, what's going on? My client says you owe $500. What do you think? And they say, well, I do owe the money, but I lost my job, and this, and I'm behind a hard spot right now. And I say, well, what do you want to do? Do you want to stay in this house? Because if you do, you have to pay. Or do you want to leave? And then listen to the answer. Sometimes the answer is, I would love to stay in this house, but I'm not going to be back on my feet for a little bit. Okay, well here's what we can do. If you'll consent to a judgment, what we'll do is, normally you'd only have 10 days to pay or move out. My landlords give me authority to give you an extra 2 weeks. So you've got 21 days. I'm only giving you 21 days, not so you can stay here for free for an extra 2 weeks. I'm giving it to you with a list. In my office, we usually have a list of the agencies that can help somebody. Sometimes it takes more than 10 days to get help. So here's the list. The highlighted ones are the ones that we think still have funds. Some of these agencies only have funds available for a certain period of the year, and once their funds are gone, they can't help anybody else. So here's the ones we think might still be available to help you. Contact all of them and get the ball rolling right now. Take your consent judgment to them and let them try to help you. If they can, great. If they can't, you've got extra time to get out. Is that fair to you? Most of the time the tenant says, you know what, I appreciate that, you gave me some extra time. Did it cost my landlord really anything? Not that much, 2 weeks. But hopefully the tenant is realizing that we're trying to be fair and work with them so that that place doesn't get damaged on the way out the door. That's the other thing. I don't want a tenant damaging the place on the way out the door. What I really want is a tenant calling me and saying, look, I'm moving out Saturday. Can you have somebody meet me and pick up the keys? Heck yes, because if that house sits vacant for the weekend, I'm going to come back to a shell. Yes, I want to meet you there. Yes, I will. Yes, I will drop everything and be there to change the locks or to do whatever, to make sure the lights are on or do something, board the windows or cover the windows so it doesn't look pure vacant. Yeah, absolutely, I'll be there. All right. So if I can cut a deal with the tenant and give them an extra 2 weeks, hopefully I get that kind of consideration back. But also sometimes I pull the tenant out in the hall. Tenant says, I hate that landlord. This is a terrible house. Look at all these pictures, and they drop it, it's like right to the floor. The house is just terrible. You look at that, you shake your head, and I usually say, hey, listen, I wouldn't live there either. I don't blame you. But you can't stay there for free while we're fighting about that. I mean, if it's terrible, move. I don't blame you. Why don't we do this? My landlord did not sue you for a money judgment. So I'm not going to be chasing you around for the $600. Why don't you take the 10 days and then go ahead and sue? And I'll write a letter to my landlord that says, look, I saw pictures. That's not going to fly. You need to fix that stuff before you put somebody else in there. And this lady's going to be out in 10 days. And usually that works too. They feel better that they got a chance to tell you. I can't tell you how many times I've looked at a dirty basement. Whatever. I'd be happy to look at your dirty basement pictures. Or this, that, broken glass, or whatever. Okay, all right. They feel better. Everybody feels better that they got their chance to say it, to show what is wrong with this place. And I think sometimes tenants are surprised that I agree with them. Yeah, that's terrible. So what do you want to do? If you're staying, you got to pay. If you're not staying, then it doesn't matter how bad it is, you're moving, right? So let's get it moved. But the thing is this, if you're a real landlord, I don't know who else is landlords here, you got to fix it. Now, those are things that we try to do. If that all doesn't work, then you've got to go to trial. All right? Here's the tricky thing about the trial. The Michigan court rules apply to the trial. What that means is that written note from the neighbor who says they saw X, Y, or Z isn't going to fly. All right? Saying that you talked to the police and that they saw that there was drugs at this house isn't going to fly. It's a trial. So if you're going to bring some evidence in, it has to be legally admissible evidence. You have to bring in the person. All right? Bring in the neighbor. Or bring in a police officer. Or do whatever. Now, how often is that going to happen? Not very often. Normally, it's the landlord. Same. I rented this house to Sarah, right? I rented this house to Sarah. Sarah didn't pay me. And it's going to be Sarah standing there saying, look at all these pictures, this house isn't very nice. Okay? That's what's going to happen. Normally, or what should happen, is that the judge says, okay, Sarah, I understand, but you did live there. You did have a roof over your head, and the furnace worked, and the hot water worked, and everything else worked, right? Except for those defects, whatever those defects are. I tell you what I'm going to do. I'm going to cut the rent in half for that month. You owe $300. If you don't pay it, you have to go. That'd be great, all right? Because now there's been an adjustment for you, because you're paying $600, you got an adjustment, and the landlord now just got hit with it. They know that they've got to fix it, or else they're gonna be in a situation where they're not gonna collect their full amount of rent. I will tell you, I've only seen it happen once or twice, because normally what happens is the whole show stops right there. And they say, well, we're going to have a trial, but it won't be today. I'm going to adjourn this a week or 2 weeks or 3 weeks so that Sarah can go get a lawyer, and we'll see what happens in 3 weeks. And nothing got resolved. In 3 weeks, you show back up with a lawyer or legal services or by yourself, and we argue some more, and sometimes it gets adjourned again, depending on what court you're in, and maybe again, and maybe again, and maybe again, and then finally, at some point, you might get evicted, okay? And or you might have moved because you're so frustrated that whatever it was still wasn't fixed. Again, that's why one of the things I like to do is pull everybody outside and try to resolve it. All right? I think it's in everybody's best interest if you can do that. So those are the landlord considerations. There's a lot more intricacies out there. Yeah.
I just wanted to be clear that a police report, a landlord cannot take a police report in to record as evidence.
Technically, no. I mean, there are some judges that may allow it, okay, that might review it, or there's some wiggle room about how it could be admitted as evidence, but as a technicality, you as a landlord didn't write that report, right? You didn't interview the witnesses, you didn't write the report, you didn't author it, you cannot validate it, okay? So as a foundational requirement, it's not your piece of evidence. You need the author of the report in order to be able to get it in. And if you don't have the author of the report there, in theory, it should not come in. But I will tell you, in the real world, you know, it's a little bit looser because it's not as formal, so some judges might allow that, or at least might consider the content of it to help you out. But still, I will tell you, if you ever go sit in 68th District Court in any of the courtrooms and watch, there will be people that come up to the podium, landlords and tenants, who haven't spoken to each other. Most of the time, the judges will send them back out in the hall. Have you guys had a chance to talk? No. Well, go back out in the hall and see if you can work this out. Don't waste all of our time arguing about it right here. Go figure this out. So, I think it's prudent just to go do it on your own anyway. All right. There are some other notices to quit. One of them is a health hazard. If you're a landlord, you go by your house, and the house is in shambles. And I don't just mean dirty. I mean, there's a huge hole in the roof that wasn't there yesterday. The tenant did it, or the doors are open and wide open. They're just gone. The doors are off. The hinge is gone, and it's December. I mean, if there's something crazy going on, you can file an immediate health hazard. There's some health hazard notices that could be in there. There's also some drug ones that you can do. All right, if you believe the house is a drug house. In fact, if you're a landlord and you believe the house is a drug house, you have a duty to do some evicting, or else you could lose that house to a forfeiture. What I mean by that is this: if they come raid a house and they serve notice, they usually will serve notice on the landlord that they raided your house on Jones Street. If they do that and you don't take steps, and they have to raid it again and again and again, and you still haven't done anything, because your tenant, although they may be a drug dealer, they're paying very well. They always pay the rent on time. Well, that's not going to fly. You could lose that house to forfeiture because that's not appropriate, okay? So you have to take steps. In that case, you take the police report, you attach it to the complaint, and you jump into court. Most of the judges in the 68th District Court will accept that. There's a couple that will still want the officer to come in. All right, so, but around here, if it's that situation, we do get the police report, we get the officer to go in. And it does happen, I'll tell you. I've seen them try to forfeit a house before because it's been a known drug house. So if you don't want to lose your house, pay attention to that. The next thing on the outline is tenant considerations. This seems extremely easy or basic, but I will tell you that I think it does matter. Is that step one is to verify the terms of the lease. Honestly, that is a big deal. What I mean by that is, what did you as a tenant think that you were going to pay? In other words, how much were you going to pay? $500 a month or $600 a month? Make sure you understand that. We have Judge Marable here. Good afternoon, Judge. How are you doing? 68th District Court Judge Marable's here with us. Also, verify the term. So if you have a written lease, you could have a term of 1 year, a month to month, 2 year. So verify that's the term that you want, because there's consequences if it's not the term that you want. So you have to verify those. Verify whose responsibilities are what in the lease. Sometimes in the lease, the landlord's going to be responsible for the water. Sometimes the landlord's not going to be responsible for the water. All right? The lease should spell out exactly who's responsible for what. As the tenant, I think you should be very, very careful to review that lease and make sure that it says what you think it says. Again, I will tell you, I have people come to my office and sit down and say, my landlord is trying to make me do X. And I say, okay, well that might not be fair, that might not be reasonable. Let's take a look at the lease. We grab a hold of the lease, we flip through it, we take a look. And on page 3, it says the landlord made it your responsibility to take care of fill in the blank or whatever it might be, the electric or something. So what I tell everybody is double check the terms of the lease. Make sure it's what you want. Some of the other things are pets. I will tell you too, some leases flat out say you cannot have a pet. If the lease says it, that's your contract between the parties. So if the lease says you can't have a pet, you can't have a pet. If it's not fair, I'm sorry, it might not be fair, but that's the way it is. That's the lease that you agreed to. Before you signed it, you had a chance to negotiate it then, or to go find someplace else. If you really have a cat that you want to bring, some of these landlords will allow for a cat addendum or a pet addendum, where you pay a little extra deposit or something, or pay an extra cleaning fee, because they're afraid that there might be some smells or something associated with it. So they go ahead and allow that. If your landlord doesn't allow that, then you can't do it. So again, verify the terms of your lease. Step 2 for the tenant is you got to inspect the property. You have to. That's the best way to protect yourself. Some of these things you can figure out just by visual inspection. What I mean by that is walk through. When you move in, we've already talked about the move in, move out checklist. The landlord is supposed to give you 2 copies when you move in. All right? You have 7 days to fill that out. I can't tell you how many times people don't bother to fill them out. Or tenants don't realize they have the right to ask for those. Okay? You have the right to ask for that. Take that move in, move out checklist and go through it. Note the screens, or note the paint, or note the spots in the carpet, or whatever it is that you want to note. Note it, keep a copy for yourself, sign it and date it, get it back to the landlord. Okay? It's important that you do keep the copy for yourself so that then you can go ahead when you move out and remember what it was. I see that every now and then too. The tenant fills one out properly and turns it in, but then as soon as they turn it in, they didn't keep a copy. They move out a year later and they don't remember. They say, I know I filled one out, but I don't remember. Well, we asked the landlord may or may not have it. Oddly enough, sometimes paperwork gets lost. Sometimes it's still the landlord's advantage for the paperwork to get lost. And now you know, what do you know? The only copy of the move-in sheet is gone, so we have a move-out sheet that we can't verify anything on. Okay? So for the tenant side, you gotta keep those, so that way you can review it. The next thing is, pay the rent pursuant to the terms of the lease. That sounds ridiculously simple, doesn't it? Just, if you agree to pay $500, you pay $500. But I know in practice, it's not that simple. Sometimes things come up. I don't mean life things, I mean issues with the house. You might have an issue with the house. Usually, let's say it's leaks. There's a roof leak, or there's a leak in the basement, or something like that. What I like to tell everybody to do is to notify the landlord. Notify the landlord. I prefer that you do it in writing. Notify the landlord in writing. I've got this issue. Please come address it. Give them a chance to fix it. They need a reasonable opportunity to fix it. If they fix it, great. They've done what their job is supposed to be. They've gone ahead and taken care of it. If they don't fix it, though, then I think you should withhold some rent. But I don't think you should just withhold the rent. What I tell everybody to do is this. Send them notice that says, I told you on May 15th that there was a leak. I never heard from you. It's now June 1st. I'm withholding June's rent. It's better if you can put it in an escrow, but you probably don't have an escrow or separate bank account available, but keep the money to the side. I'm not paying June's rent because you haven't fixed it. All right? Now, if you do wind up being taken to court for a 7-day non-payment of rent that we talked about, now you have the ability to argue. This isn't a surprise. I notified you on June or May 15th that this is leaking. You didn't do anything. Now, it's June 1st. You didn't do anything. And now here we are in court, June 15th, it's still leaking. You have a duty to fix that. What that is there's a requirement that says that the house has to be kept for its intended purpose. That's a duty that the landlord has. So they have a duty to maintain the property. If they're not maintaining the property, then you have these remedies. Depending on what they are, they may be more serious. You may not have the ability to wait 2 weeks. If there was a storm and a tree branch fell and poked a big 6-inch hole in the roof and it's leaking like crazy, well, I can't wait 6 weeks for you to fix it. You need to know about it right now. All right, notify them. I've had to tell tenants before, you can't live like that. If you want to, go there and fix it. Keep all your receipts. Be fair and reasonable about it. I mean, you've got to wrap this up if you can. You can't leave it. Okay? Obviously, it's not going to work to anybody's advantage if it makes it a worse issue. So that was step 4. Notify the landlord immediately if time permits. Now there are a million different variations of everything that we're talking about today. Okay? I will tell you that Michigan no longer allows self-help. Self-help used to be where a landlord could go collect his rent and do certain things because he's the landlord. All right? Like, I'm going to kick you out of this house on my own without a court order because you owe rent. Well, they don't allow that. And it's good that they don't allow that because landlords would probably go do it all the time. But landlords have a right to do some maintenance work. Okay? So let's say you call up and you say to the landlord, it's December or January, hey, there's an issue, the front doors are sticking. Whatever. Something with the front doors. But the tenant hasn't paid the rent. So the landlord decides, okay, I'm going to go ahead and take care of this. We're going to immediately address your problem with your doors. And they go ahead, show up with workmen, and they take the front doors right out of the house. There were real cases that happened before, a long time ago. So now there's no front doors in Michigan in the middle of winter. Landlord didn't kick you out, right? He didn't tell you you had to leave. You're welcome to stay there. But you're going to freeze in that house. That's called a constructive eviction. That's not allowed anymore either, which is a good thing too. Okay? But those are the things that used to happen, and now they don't get to happen anymore. But you have to be careful. Nowadays, we see stuff like that starting to crop up again. More self-help. It's not allowed. Tenants have to be available and paying attention to protect themselves. But landlords have to understand that there's huge consequences to things like that. You can't take away the doors. One of the things that people always ask me is, do I have the right as a landlord to enter the house? Sure, absolutely. Within reason to secure the property. Okay? Well, what's that? I guess it kind of depends on what is the problem. If somebody calls you up and says, I've got a screen, a couple of my screens have holes in them. Well, can you run over there at 2 o'clock in the morning and fix it? No, that'd be ridiculous. If somebody calls you in January and says, hey, the furnace went out, we're freezing. Can you go over there at 2 o'clock and fix it? I think you probably better. You probably just better get on it right now immediately. Okay? So it kind of depends on what the circumstances as to whether or not you guys could run there as landlords and do that. I was hoping you guys would have a lot more questions. We got through my whole outline pretty quick.